Welcome to Casual Conversations on Education, where OIDEL is interviewing experts from the fields of human rights and education. Today, we're going to talk about the universality of human rights. Universality is the central idea of the Universal Declaration of Human Rights and the foundational aspects of the entire human rights system. And yet, despite its foundational nature, the universality has been questioned and distorted and maybe even threatened in recent years. And with us to talk about those trends and a better way forward is Dr. Gabriela García Escobar. Hello, Gabriela.
Hello, thank you for inviting me.
Thank you for being with us. Gabriela is a professor of public international law and international human rights law at Universidad Panamericana in Mexico. She holds a PhD in law from the University of Geneva and a master in international law from the Graduate Institute of International and Development Studies of Geneva. Again, Gabriela, it's an honor to have you with us.
It's an honor for me too to be with you.
Thank you. You have recently published a book titled Plurality as the Core of Human Rights Universality, Rediscovering the Spirit of the Universal Declaration of Human Rights of 1948 through the right of self-determination. First question, what is human rights universality and how did you get interested in that topic?
Well, the topic of universality, although many people think that this is pretty settled, actually is a very complex issue because we can explore universality in different senses. So most of the literature has focused on universality in terms of who is the rights holder of human rights. But actually, there is not much question about this because who is the rights holder of human rights? Everybody, every human being. So we don't have a question about this. This is not disputable. We have a second aspect of universality that has to do with the concept of human rights itself. So there is a dispute about whether the concept itself it's a Western product or if this is actually universal, if this is shared by different cultures and philosophies, religions, traditions of the world. This is something that is disputed. There are a lot of articles about this, but the focus of universality that I use in my book has to do with a third approach to universality that has been barely explored in literature, that has to do with the universality of interpretations, also called standards of human rights. And I decided to explore this concept of universality because if we look at human rights treaties, especially if we look at the origin, the Universal Declaration of Human Rights of 1948, we're going to see that human rights are encapsulated as principles. Principles are general and abstract. For example, everybody has the right to life, or everybody has the right to education. And this is pretty abstract, this is pretty general. And the intention of the drafters was to put some clauses that were actually general. Why? Because if you want a treaty to be adopted universally in terms of the participation of many different states with different cultures, with different legal traditions, then you need to put general clauses in a treaty. The more specific the clause is, the more culturally charged it is going to be. So that's why it's going to be harder for it to be adopted by a larger number of states. That's why they decided to put these terms in pretty minimal terms. So they can be actually universally shared by a lot of different cultures. But with the development of different international mechanisms of human rights protection, we are witnessing a proliferation of different interpretations of these general clauses in different fora. For example, we have political forums like the Human Rights Council, the General Assembly of the United Nations. We have quasi-judicial forum like treaty bodies, treaty monitoring bodies, for example, the Human Rights Committee. And also we have jurisdictional mechanisms like regional courts. We have, for example, the Inter-American Court of Human Rights, the European system, and the African system. And I decided to explore this concept of universality of interpretations because these different mechanisms are taking these general clauses and they are giving concrete content to them. And this concrete content actually is questionable whether this is universally shared by different cultures and philosophies, traditions of the world or not. So the work in this book is to explore this concept of whether these standards or interpretations as adopted with very concrete terms, with very substantive content, whether they can be called universal in terms of the universality of the Declaration of Human Rights as a transcultural consensus, as something that is shared by different cultures, different philosophies, different religions of the world. And I realized that this kind of universality is really hard to reach. And this is really hard to reach because, as I previously said, and this was something also said by the drafters of the Universal Declaration of Human Rights, and also by some philosophers like Jacques Maritain, that the more concrete the content of human rights becomes, the more culturally charged it is going to be, and the more parochial it is going to be. And this is not a conscious exercise. This is something that we do unintentionally, but because we're cultural beings. But this is a topic that I try to explore in the book. Also because I realize that in literature, this is something that has been barely explored.
Mm-hmm. Mm-hmm. Yeah, I was surprised to read the book, and it seemed to me such an important topic and so obvious. But as you say, I haven't seen much literature about it, so I'm really grateful for that work. So maybe to go a bit more specific now, you said that the more concrete we make those norms or interpretations, the more culturally charged they are. And with different examples, you show that this is exactly what happened. You have observed that interpreters of those laws have often adopted a framework of liberalist universality, as you call it. What is that, and where does this framework of interpretation come to light most prominently?
Yes, I use the term liberal universality to call something that I think is a kind of phenomena of using a very specific interpretative paradigm by international human rights mechanisms of protection. And this framework of interpretation consists on considering that the anthropological foundation of human rights in general is a very specific anthropological view that relies on the vision of a human being as an individual that whose main goal is to pursue personal autonomy in all the different spheres of life. And this is seen, for example, in the individual as somebody that has to be released from the bonds or the attachments that surround this person. The attachments to family, the attachments to community, to religion, to culture, to place, even to time. And there is a tendency of considering that human rights have the objective of conducting this task of liberating the individual from all these attachments. Because they don't say it, but unconsciously is a way of saying happiness, the good life of the human being is personal autonomy, is to be liberated from everything that surrounds us. And this way of framing universality, I called it liberal universality. There is a previous work that has been done by Professor Seth Kaplan in a book called Human Rights in TIC and Teen Societies that was published in 2018 by Cambridge University Press. He also researches on this concept of liberal universality, but he calls it Western universality. But I consider that the term Western is not correct, because when we speak about this very individualistic and autonomy-oriented view of the human being, this is not the whole tradition in the West. This is a very specific part of the Western philosophical, cultural, and religious tradition, because it comes religiously from Protestantism, philosophically from different philosophers of liberalism. We can speak about John Locke, Stuart Mill, about Hobbes, and I think it's unfair to say that they are the whole Western tradition. That's why I decided to encapsulate this term as liberal universality, because we have other Western traditions that are more interdependent, that are more communitarian, and are also from Western origin, but that are also shared by different parts of the world. And what I do in the book is to contrast this view of universality, the liberal universality, with the view of universality that was envisaged by the drafters of the Universal Declaration of Human Rights. Because when they realized that human rights norms were only universal to some extent, to some minimal extent, in an abstract and general sense, they realized that the proper way of keeping this universality was to leave a space of maneuver to states, to different societies, so they can take these human rights norms and adapt them to their different cultural, social, political, and economic traditions, which is something that is in line with the right to self-determination. That's why there is a chapter that says the universality of the Universal Declaration of Human Rights in action can be made through the implementation, a holistic implementation of the right to self-determination. And I decided to call this a way of framing universality, the universality of interpretations, as the pluralistic universality of the Universal Declaration of Human Rights, in contrast to the liberal universality. Because the liberal universality establishes a very specific view of the human being, and everything that does not align with the goal of personal autonomy, everything that has to do, for example, with duties, with responsibilities, with other social goals, we can take, for instance, also solidarity, is something that they consider should be excluded from the human rights debates. And I put several examples of these discussions at the Human Rights Council, for example. In contrast, the pluralistic universality of the Universal Declaration envisaged that these general norms are very flexible. They can be adapted to very different contexts. So something that will be totally inadmissible for liberal universality actually was embraced, and I will even say celebrated, by the drafters of the Universal Declaration of Human Rights. And this is a view also shared by Seth Kaplan and by Marianne Glendon. Because for the drafters of the Universal Declaration, this pluralism was open to other views of the human being, more interdependent views that are shared by most of the population of the world. Most of the cultures of the world are more independent than the view pursued by liberal universality. And they welcome, for example, intermediary communities. They welcome attachments to family, responsibilities, bonds to culture, because in the words of Charles Malik, who was one of the drafters of the Universal Declaration, these attachments to intermediary community are ways of promoting human flourishing, because we need the help of others, we need the help of institutions, of communities, in order to understand ourselves and to understand other human beings, so we can grow professionally, personally, spiritually. And this is a contrast that I made in the book between these two forms of universality in terms of interpretations.
Mm-hmm. Mm-hmm. And you say that you also see examples of that in the Human Rights Council. What, for example, did you see there specifically?
For example, I narrate in the book, there were several sessions about something that they call, I think in a way that was pretty pejorative, traditional values and human rights. And there was a workshop about this. And I think the workshop was not a good idea because there was already a prejudice on the part of the people that that pursue this way of framing human rights in terms of liberal universality. So when they think about traditional values, because they see the human being as an abstract individual that must be liberated from all attachments, they automatically think that, for example, the family, religion, or culture, they are ways of oppressing the individual. Mm-hmm. So I think that at the beginning of this workshop, there was already this prejudice that this is something wrong, this is something that has to be erased. And many participants, I think that they were not open even to consider that for many people in the world, these attachments are cherished by them, and they are ways in which they find meaning in life. Mm-hmm. And at the end of the workshop, it was really hard to find some agreement between the different positions because many proponents of liberal universality, mainly Western NGOs and governments, they were really reluctant to accept that these bonds, that these intermediary communities can play a role in providing human flourishing for different communities.
Mm-hmm. Yeah, in our work, we see a similar skepticism sometimes too, because we work a lot with non-governmental schools, for example, or with parents, and we see that skepticism also there. So, for example, we just published this we just published a new research called Freedom of Education Index. But what we realized when we were talking with a lot of different schools, local schools in different parts of the world, a commonality that we saw in the feedback was that yes, we are allowed to exist, we can have non-governmental schools, but there's more and more restrictions on the curriculum, because especially faith-based schools are struggling now with impositions from the state on a certain view on sexuality and how to teach sexuality, when and who, and yeah, at what age. And so this restriction, because there's no trust in the school or in the faith community for them to determine a culturally acceptable way of transmitting an idea, and it's almost seen as oppressive if it's not done in the way that the state would do it. And then it's in the name of human rights, which is a problem. And I think your framework with the more of with an interpretive framework of a pluralist universality, it would be extremely helpful there and liberating for many, especially non-mainstream groups. You advocate for a pluralistic approach to human rights that respects diverse cultural and philosophical traditions, as you mentioned. How do you propose international human rights bodies practically implement such a pluralistic approach while, of course, maintaining international human rights standards? Let's start there. How do you think that those mechanisms can actually implement this?
The proposal of the book is that the way in which I think we can implement this is, first, I think it has to be through a coherent view, of a rational view of the whole system of international law, because there is a trend in the human rights sector to try to develop different sources, different rules of responsibility for the state, the different rules of interpretation in the field of human rights, as if human rights were a totally independent field from international law. And I think this is dangerous, because the more we depart from the origins and from this coherence in the system that is built upon certain principles, a certain rationality, I think that the more chaotic, unstructured, and politically charged this is going to be. So the proposal of the book is to set back the field of international human rights law into a general international law by conceiving that this is a system as a whole, by going back to a holistic view of the right to self-determination. And I decided to explore the right to self-determination because this is a human right. This is one of the main principles of international law. This is established in the UN Charter. This is even considered as a norm of jus cogens by the International Law Commission. But despite of this high status of the right to self-determination, as an underpinning right that permeates the whole international law system, this right has only been explored in the context of the colonization, and there are some works about secessionist movements. But actually, if we look at the drafting history of this right as a human right and as a principle of international law, we are going to see that the right to self-determination was something broader, because it does not only refer to political and external self-determination. It's not something that is close just to the independence of a new state, but actually is something that encapsulates economic, cultural, and social aspects. So that means that each society has a right to decide their cultural, social, political, and economic systems. Obviously, this freedom is not unrestrained. As an exercise of freedom is not unrestrained. But I think that liberal universality has to be more flexible in order to recognize this freedom. I think here there is a paradox, because the framework of liberal universality advocates for more freedom, but actually in the name of freedom, they are curtailing essential freedoms that are contained in human rights treaties. So I propose in the book a different way of framing freedom, not only in terms of a liberal freedom, we can say, a freedom understood just as a way of getting rid of attachments, but freedom as also commitment, because a true exercise of freedom also incorporates a sense of having a commitment, having an attachment with somebody, with a culture, with a country, with a religion, in order to exercise those ideas that search for truth, that search for meaning in a meaningful way. Mm-hmm. And I think that the right to self-determination can provide this space of acknowledging that there are different ways of understanding the good life, different ways of understanding human flourishing, and not just in liberal terms, but also in terms of commitment, in terms of responsibility, in terms of living according to a specific culture, or living according to a specific religion, to a specific tradition. And I think this way for human rights treaty bodies to operate in order to recognize these different perspectives, that's why I call the book Plurality as the core of human rights universality, because we need to recognize this pluralism, because I think that the way in which human rights mechanisms have acknowledged diversity is in a very restrictive way, because it's in a way of saying we are going to wear different clothes, eat different food, we are going to look differently, but inside we have to think in a very specific way. We need to develop this liberal universality framework inside of our minds and inside of our cultures. And I think that a broader and deeper form of plurality is for human rights.
Oh, I think it cut out.
We think. and the ways in which we perceive the meaning of human existence. I think we lost it. Oh, no, it's okay.
It's back. I think it cut out quickly, but I think it's fine.
Okay, perfect. So I think that human rights mechanisms, by recognizing this holistic view of the right to self-determination, can provide a space for recognizing different ways in each community for looking for human flourishing, for the meaning of life. So I think that the best way to implement this is through the right to self-determination, because it's a right that we already have that is part of the system, that was incorporated also with this purpose. And this is something that is mentioned barely by Marianne Glendon in her book about the Universal Declaration of Human Rights. So we have to use the means that we already have in international law. We don't have to create something new. And also we can implement this by giving more robust content to the principle of subsidiarity, which is also a principle that is already there, just it has not been developed so much by treaty bodies or by the Inter-American Court of Human Rights. But we can find some examples of this use of subsidiarity and this use in some sense of the right to self-determination for these purposes in the European Court of Human Rights. For example, with the use of the margin of appreciation. Although many people in the human rights sector, they are really very reluctant to the use of this margin of appreciation, because they think that this is something used for the protection of national interest of an oppressive minority. Actually, the usefulness of the margin of appreciation or of the right to self-determination is not to protect the interest of a minority, is not to protect the interest of the state as an abstract entity, but is in order to recognize these different ways of understanding human flourishing, these different cultural forms, these different hierarchy of values, these different ways of living. That's the purpose of this right. And I think that this is something that has to be acknowledged, because we already have a lot of different studies. We have a lot of research that proves this point, that most of the world, they do not embrace the paradigm of liberal universality. Most of the world population, they don't see themselves as individuals, abstract individuals detached from their community, detached from culture, from their family, in order to be happy. Actually, most of these research, mainly we can find it in the field of cultural psychology, demonstrates that most of the people, they cherish these attachments. They cherish these duties, for example, that they have with their families, these responsibilities that they have with the communities. They cherish their religions, because most of the world, of the population of the world, they are very religious, except for some parts of the Western world. And most of the people, they love the cultures. Obviously, there are some parts of our cultures that we don't like them, but they don't see these spaces as spaces of oppression. This is a narrative that has been framed by liberal universality, but actually the common people, they don't think in this way. There's a lot of the research on this issue. But I think that beyond these legal tools that we already have, the principle of subsidiarity, the right to self-determination, the margin of appreciation that can be used by different human rights mechanisms, I think that the key aspect that needs to be adopted in order to implement this pluralistic universality is a change of mind, a change of interpretative paradigm in the mind of the interpreters, of the people that are in Geneva, that are in New York, that are in San Jose, that are in Strasbourg. I think that's the key, because the legal tools, they are already there. The rationality of this, the coherence with the whole system is already there. Just we need the academic, the intellectual, and the political will to implement it.
How do we do that? And did you already have seen have you already seen some changes in that direction?
Not yet.
Yeah.
But I think we are there, because when I speak to many different colleagues about my research, and also as I spoke to you before the recording, many people tell me, oh, I already had that intuition that this is happening, just I don't have the academic or the legal tools to explain this. And I think that the book has this purpose. The book is not going to give a magic recipe for how to solve this issue, because I think this is very complex. And I think this will take time, also because many of these studies on cultural psychology, they are pretty new. They started in 1990s. But I think that little by little, when we speak to different colleagues, also, we shouldn't be afraid of speaking, because I had some terrible experiences of people working at the UN system that when I spoke to them about this subject, they were very angry. And actually, one of them told me that I should be in jail just for speaking about this. So I think we need to try to find ways in which this political atmosphere needs to be more academically oriented. We have to go back to the principles that created the United Nations. We have to go back to consensus, to dialogue, and to listening to different ideas, and don't be afraid of different ideas, because I think that this is something that is happening right now, especially in the Human Rights Council. I think you already had the experience with that. But I think we need to speak with arguments, show these kind of researches, contribute with other people that are working in these areas, and try to look for friendship, to try to build bridges with different people, so we can share these ideas, and we can little by little find some common ground to share these concerns. Because the point of this research is not to impose an agenda, is not to impose an ideology, is just to respect human dignity. And we are not respecting human dignity if we are imposing a view of how they should understand human flourishing, and we don't listen to these people, to the people, to the rest of the world that is not in Geneva or New York. We have to listen to them and to treat them as rational and equal human beings, by acknowledging that some of the ideas in the human rights sector might be wrong. I think we need intellectual humility in that regard. But I'm really happy that I'm starting to see a change in mind with different NGOs, with different academicians, with different political actors, that they are concerned about this issue. Although it is very difficult to try to speak in some sectors about these ideas. But I'm starting to see an awakening, a concern that maybe there are some things that we need to change. We need to change them if we actually want to accomplish our task of protecting human dignity.
I think we can end on that note. I think that's a very hopeful note. So I kind of want to end there, to not crush it again, about, really to seek an encouragement, to seek consensus, dialogue. And I really like what you said, intellectual humility, that maybe the other does know something that I don't, or maybe his way of human flourishing or her way of human flourishing, although it's not mine, is a legitimate one, and one that should be given space. Should be given space. Yeah. Thank you so much. And where can we follow you? Do you have LinkedIn? Do you have Twitter? What are your channels?
By the moment, I only have LinkedIn. You can find me as Gabriela García Escobar. Also, I work right now at Universidad Panamericana, so you can find my email in the institutional webpage. And you can contact me via my email or LinkedIn.
Perfect. Also in the description, we're gonna add the link to what you just mentioned. And then anything that's on the horizon, any new research projects?
Well, right now I'm working on the sources of international law. Thinking about this way in which the structure of international law, especially in the human rights sector, is kind of collapsing. There is a tendency, there is a trend to try to unstructure the sources, the rules of interpretation, the rules on state responsibility. And I think this is dangerous for the legitimacy of the system.
Oh, interesting. Okay, I think you have a sense of choosing good topics. Eh? Thank you so much, and I look forward to hear more from you.
Thank you, Josian.